The California Private Attorney General's Act is under attack on two fronts in 2022. What does this mean for California employers and the potential for reduced litigation exposure? Now, if you're an employer in California, you've probably heard about the Private Attorneys General's Act, or often referred to as PAGA. It's a law that was passed in the early 2000s that allow employees the ability to bring these representative actions against employers for civil penalties that the state could have enforced, only the state could have enforced before. And it permits the employees to recover these penalties, and they have to share 75% of the penalties, give that back to the state. They get to keep 25% of the attorneys, 25% of the penalties. And the big kicker is that the plaintiff's attorneys also get their fees on top of it. Now, California employers have faced a lot of liability under PAGA in the last few years. It's been increasing for a number of reasons. And one is that the U.S. Supreme Court on the federal level has given some reprieve to employers in the form of arbitration agreements with employees, and has said under federal law, employers can have employees waive their ability to bring a class action against employers in arbitration agreements. Now, the California Supreme Court has ruled that employers can't have employees waive their ability to bring these PAGA claims because it's different than a class action. It's this representative action under California law. But that is now being challenged in 2022 in Viking River Cruises versus Moriana. The case is set for oral argument in front of the U.S. Supreme Court on March 30th, 2022, and it has wide implications for California employers. If the U.S. Supreme Court rules that employers can also build in PAGA waivers into arbitration agreements that would preclude employees from bringing these PAGA types of cases in arbitration, that would bring a lot of relief for California employers. Now, the case is just set for oral argument in front of the U.S. Supreme Court at this point, but we expect a decision in June or July of 2022. It could have huge ramifications for California employers if the U.S. Supreme Court rules that if employers are able to say that employees are not able to bring these PAGA cases and build that into arbitration agreements, that would bar these PAGA types of claims against California employers. Now, if you're a California employer and you're currently litigating PAGA cases, you need to talk about this with your current counsel and review some different strategies to use before the U.S. Supreme Court rules on this case. Now, if the ruling comes out in favor of employers and says that employers can have these arbitration agreements with PAGA waivers in them, there's certain strategies that employers could be taking in current litigation to protect themselves. Now, if the U.S. Supreme Court says that these PAGA waivers are invalid in arbitration agreements, that will just mean that these PAGA cases can continue as is and won't be a huge change in the law. So it could potentially have big ramifications for California employers here this summer on this case, and we'll be watching that case carefully. However, on the second front, there's a coalition of trade groups that has begun to gather signatures for an initiative to try to get an initiative on the November 2022 ballot that would revise PAGA. The initiative is the California Fair Pay and Employer Accountability Act. The website for this is cafairpay.com, and this initiative would replace PAGA and make it more friendly for the employees, give more money that's recovered through these PAGA lawsuits to employees, and also make it more favorable for employers. So this initiative is looking to revise PAGA and the payments to get more money to the employees, and revise it so that it's more fair for the employers as well. And the initiative is to curb certain abuses that are perceived and how the law has been playing out. So these two issues, the U.S. Supreme Court case in the Viking River Cruises case and this initiative, the ballot initiative here in California, have the potential to bring significant relief to California employers in regards to these PAGA lawsuits. So California employers need to be watching these carefully. And if you're currently involved in litigation, PAGA litigation, there are some different strategies that employers need to be taking in regards to these two potential items that might change the landscape of PAGA here in 2022. So please let us know if you have any questions, and also like and subscribe to our channel for updates on California employment law, and we'll be carefully watching these two items here in 2022. Thanks.